Exposition of common law and equity pleading. Merger of the two systems in the Code of Civil Procedure. Chapter 1. Pleading and Procedure, their importance as compared with other subjects. Sec. 1. What has been said of its importance? Much has been said concerning the importance of the subject of pleading and procedure in their relation to other branches of law. Professor Ramos said, "There is no part of the law on which the success of the whole system more obviously depends than on that part which is concerned with the administration of justice, or, in the largest sense of the expression, the law of procedure." Lord Coke said that pleading was the truest guide to the knowledge of the common law, the key, the inmost recess, and an expositor, that discloses and explains the most abstruse parts of it. Mr. Gould in his most excellent work on pleading contends that pleading is deemed to be the most instructive, and the most important single title in the law, that it is less thoroughly understood, in general, than almost any other. He states that, this preeminence it owes, not solely to the intrinsic value of its own exact and logical principles, but also in no small degree, to the fact that the principles of pleading are necessarily and closely interwoven, both in theory and practice, with those of every other title of the law. I say necessarily interwoven, because even the most simple of the remedies which the law affords and without which it would be practically a dead letter, cannot be obtained, without the aid of pleading. Good pleading, said Lord Coke, is lapis lazuli, the touchstone of the true sense and knowledge of the common law. Pleading is the outlet for the great body of substantive law. This is made plain by the study of the history of procedure, going back to the time when the older common law actions were wholly inadequate to furnish an outlet for advancing views of rights and duties, rendering the creation of new forms of actions a necessity, which was done under the Statute of Westminster 2d. To be a good pleader gave one an advantage and a rank among his fellows to be acquired by no other single accomplishment. It is a trite expression that a good lawyer is generally a good pleader. A poor lawyer never can be a good pleader. One who is an adept in pleading must of necessity be a thorough lawyer. Sec. 2. Pleading, said to be a science, method of study. Sir William Jones said that our science of special pleading is an excellent logic. It is admirably calculated for the purposes of analyzing a cause, of extracting, like the roots of an equation, the true points in dispute, and referring them, with all imaginable simplicity, to the court or jury. It is reducible to the strictest rules of pure dialectic, and if it were scientifically taught in our public seminaries of learning, would fix the attention, give a habit of reasoning closely, quicken the apprehension, and invigorate the understanding as effectually as the famed peripatetic system, which, how ingenious and subtle soever, is not so honourable, so laudable, or so profitable, as the science in which Littleton exhorts his sons to employ their courage and care. The subject was regarded as a science by the older law writers. Its substantial rules were regarded as founded in the soundest and closest logic. The rules of pleading are, in reality, founded in common sense, and are by no means so abstruse as, one might be inclined to suppose them. At the same time, they afford the greatest possible scope for exercising the intellectual faculties, and might, with great advantage, be studied for the mere improvement of the reasoning powers. Indeed, pleading affords the most beautiful illustration of the nature and utility of the art of logic, an art, which has also been greatly and undeservedly decried, but from which the most important advantages may be derived, both in morals and science. It would perhaps be a very desirable improvement in the teaching of this art if the examples to its rules were drawn from pleading, as this method would at once furnish both the practical application, and the proof of its utility. The actual preparation of pleadings affords opportunity for logical processes. The rules of pleading are but the means towards an end, they are the forms governing the expression of the claims of parties. Pleading may appropriately involve pure and applied logic, though the process of solving rights which are formally stated by means of pleading may take us out of the domain of pleading into that of substantive law. The two are so closely related when we come to the formal statement in pleadings, that it is difficult to view the one apart from the other. Successful demonstration and maintenance of rights depends as much upon correct, complete statement, as sound reason or logic. Full and accurate statement must be made so as to bring all the facts and circumstances before the court, that the judge may consider and decide upon the soundness and logic of the claims of the respective claimants. Pleading is conducted in a dialectical manner. Plaintiff states in his petition the ultimate facts which he expects to establish for the demonstration of his rights, while defendant may in his answer deny, or state new facts which show that plaintiff is not entitled to recover. Plaintiff replies to the statement of the new matter with a statement of such facts as will counteract the new matter stated by the defendant. Discussion in dialogue, as it were, follows. The reason or logic of the respective claims is deduced for decision by the court in aid of the ascertainment of truth, the basis of which at all times is the formal statements in the pleadings. Pleading is usually regarded as a difficult subject by students. The dark places generally appear at the beginning, but disappear when the end of the subject is reached. The difficulty comes to the beginner because he is not able to view the subject as entirety until the whole has been covered. The student should view the subject as a connected system, though it will not become apparent that it is a complete system until the whole ground is covered. It will then be seen that each part has a close connection with all other parts as comprising a whole. We must not only become masters of the various rules of pleading, but we should be familiar with the reason and logic thereof as well. The reason of the rule being known and the connection and relation of each, as a part, forming an entire structure, or a member of the whole body, it will of course be better understood and its application better known than if the rule had been acquired isolated and disconnected. Knowledge of rules, however, must nearly always be acquired in isolated form, or manner, and the parts placed together in our mind after completing our journey over the whole subject. That is the way the common law grew. It has been urged by learned men in earlier periods that a knowledge of the subject must be acquired as a science, and as a science, every part will be found wisely adapted to make the perfect whole, and of course to explain its general and particular application. And in this connection it is urged that there are few books treating it in a philosophical manner. Of the older books Stephen and Gould are pointed to as setting a standard of scientific treatment. The subject in Stephen's hands, it is said, is exhibited as a process of logical deduction, a system adopted by the courts to aid them in investigating the most complicated matter. Chitty's great work was a practical one. Of modern books Pomeroy and Bliss may be regarded as of the philosophical order. As to the best means of acquiring a knowledge of the subject, men differ. The formation of the science of pleading was by means of synthetical processes, just as all common law was constructed. In the very earliest period legal education could only be acquired by this method, students being required to attend court and study individual cases. Hale and Blackstone may properly be considered as the first to reduce the law to a formal science, and to introduce the analytical process. The analytical method of study begins at general principles, and proceeds to the particular cases to prove them. The synthetical process is directly the reverse of the analytical. It is beginning with the particulars, and ascending to the general principles. For example, Blackstone contains a collection of the general principles of the science of the law. It is made up from particular cases, statutes and history. Stephen's pleading is an example of the analytical process. In respect to the science of pleading, he has gathered the rules of pleading from particular cases, classified and arranged them. One may read this work and then read the particular cases. Or, the student may cut a path for himself through the tangled growth of enactment or precedent, and so codify for his own purposes. Modern educational methods are such that skilled educators have selected from the tangled growth of precedent a sufficient number of judicial decisions to display distinct subjects as an entirety, and thus synthetical processes are being pursued in reference to the subject of pleading in educational work in leading law schools. The question for the consideration of the student is, which is the best method of acquiring this very complicated and difficult science? Expressing an individual preference because of the peculiar nature of the subject of pleading, it would seem that a course of study in which both the analytical and synthetical methods are blended is the most desirable and efficacious. Textbooks are useful in presenting a connected and systematic view of a subject, and are very important in disciplining the mind to a conservative and connected view of a subject. On the other hand, the synthetical process is the examination of the particulars deducing therefrom the general principle, or as applied to legal study, the reading of the reports of cases where rules of law are formulated, giving one a more complete and perfect understanding of the principle in its practical application. Applying these processes to pleading, it will be remembered that our civil procedure is now a codified system. The code is the basis and starting point for us now, and in order to know how it came to be, we must pursue the synthetical process by studying the particulars of its history.